Restitution is a theory of liability that provides for recovery in contracts, torts, and other types of cases, and the purpose is to disgorge unjustly gained profits. It's a gains-based recovery theory. The plaintiff can claim back the gains made by the defendant rather than claiming back based on the losses to the plaintiff. So the awards based on gains, and they can be actually much higher than the losses. The beauty of restitution, other than the fact that the gains and the awards can be higher than those lost by the plaintiff, is that it can be used when contracts, torts, and other claims fail. It's a catch-all. It's often used in breach of fiduciary duty cases. There are essentially three elements: benefit to the defendant, enrichment; 2, at the expense of the plaintiff; and 3, was the defendant unjustly enriched. Remedies available under restitution are those available under tort damages at law, quantum meruit for quasi-contract, where there was no contract but the defendant must pay for what was provided by the plaintiff. Other equitable remedies are the equitable lien, the constructive trust, and also punitive damages are available in restitution cases that involve malice in California and some other states. A constructive trust is a trust imposed by the court to facilitate transfer of the property from the defendant to the plaintiff. It requires that the property can be divided for delivery. It's not general, must be specifically traced to the wrong. So where property like cash is commingled, the lowest intermediate balance is used to try to decide whether this cash that was held by the company was actually can be traced to the plaintiff or not. So constructive trust is used often for titles to properties and those types of issues where the defendant holds the title, the court deems it's held in constructive trust, and then needs to be passed to the trustee, which is the plaintiff in this case. So it really enables them to transfer title when it's a clean-cut situation like this. The equitable lien, on the other hand, is a claim, charge, or security interest against the property, and this can take place where the property cannot be cleanly divided and passed in this way. So in the equitable lien situation, the property, when it's sold, the security interest has to be settled out of the proceeds of the sale, and the defendant pays the plaintiff out of the proceeds of the sale, and then that's the point that the lien is removed. There are various defences available in a restitution case. One is volunteer. There is no recovery for volunteers or officious intermeddlers. So this is linked to the second one, which is the expectation of compensation. If there's no expectation of compensation, then restitution cannot be a valid claim. So these expectation of compensation cases often involve marriages, where one spouse claims restitution against the other one, and the courts have deemed that there was no expectation of compensation for what the spouse provided. Often in cases things like one spouse supported the other one through law school and things like that. Laches or the statute of limitations are other defences against restitution cases. Sleeping on your rights has prejudiced the case. There's a defence under laches. And then, of course, as this is the case in equity, unclean hands in this matter can also bar a successful claim. There are essentially 5 components to a restitution case. The first one is looking at the enrichment. Was the defendant enriched? Second issue was the enrichment at the expense of the plaintiff. Third element is whether the enrichment was unjust. Fourthly, the court will look at the defences, such as volunteering, laches, unclean hands, and whether there was an expectation of compensation that was reasonable. And then the fifth component is the remedies. And there we have the tort damages, quantum meruit, the equitable lien, constructive trust, and punitive damages, where the action of the defendant needs to be punished. Quantum meruit provides the measure of damages in many restitution cases. It's the principle that the equity court should award people as much as they deserve, and it actually stands for the amount merited in Latin. The elements of a quantum meruit case are